That's the sound of the police. Whoop, whoop. That's the sound of the beast.
We have ourselves a Tyrant alert, folks. Are you as excited as I am? Because I'm pretty excited. It's a slam dunk lawsuit, says Warren Bush, who obviously is a well-known and respected attorney. He's wrote several learned treatises on what is or isn't a slam dunk lawsuit. Tom Mann says, follow up, please don't let this die. Dave, just Dave, recites or copy pastes a portion of the Ohio Code. Okay. News Now Ohio wants to get involved. He can't wait to get his own misdemeanors going because, you know, it's going to be exciting. Max wants to mirror it so Max can get his cut of the income for it. Why is there no phone numbers? Because reading is fundamental. Well, what do we got here? Let's figure out what we got here. Look, there's a phone number. Yeah, reading. What we have here, he says that he's going to go and audit the Alliance Police Department at 470 East Market Street in Alliance, Ohio. 470 East Market Street in Alliance, Ohio. 470 East Market Street, Alliance, Ohio. But this says it's Alliance Municipal Court. Could it be not just a police department? Could it also be a courthouse? We're going to go to 603. Because I want it. Because I want it. All right, we're going to listen to this a little bit. We're going to see what happened. We're going to see where he went totally and completely wrong. His interaction with the police started around the 2-minute and 50-second mark, I believe. Right there. This lady, actually, she's, when it says right here, and here comes the tyrant. So 2:19 roughly. He's filming. He has a love affair with these 3 notices, and I don't know exactly why he has such a love affair with those 3 notices. I would love to have seen what, there's some notices posted on the front of the desk there at the screening machine. I would really love to have known what those said. But anyway, it doesn't really matter terribly much. So about 4 minutes of him arguing with the police has gotten us to this point.
Well, I'm trying to make you leave. You have it, so now we have business with you. So you do have.
But you're asking me to leave a public water.
Sir, let me explain this to you.
You can't force me to leave a public place. I haven't gone beyond that door.
You want to bet I can take you upstairs and have you talk to the judge, and I bet he'll have the.
You can make me leave a public place.
Absolutely. If you have no business. If you have no business in the courthouse, you could be asked to leave.
I'm not in the
refuse to do so, you could be charged and arrested.
Okay.
All right.
Well,
So
I'll let you go with that.
with you. Now you're going to provide me with your ID or your name and date of birth.
I don't have my ID.
Okay. What's your name?
Doug.
Doug what?
That's all I can give you.
Well, sir, at this point, you're going to provide me with your information, or you're going to be arrested for obstructing.
For obstructing what?
All right. So we got some real relevant facts in that 50-ish second clip. Number 1, there's a judge upstairs, and this is a courthouse. Number 2, we've asked you to leave, and you haven't left. That's why I get your ID. And number 3, there's going to be a obstruction charge. Now, first thing is, can you film in that courtroom? The answer is yes, if you do the process right. The judge assigned to a trial or hearing shall, that's must, basically. Shall is a must. Permit the broadcasting or recording by electronic means and the taking of photographs in court proceedings that are open to the public. So if it's a court proceeding that's open to the public, the court shall permit the broadcasting or recording by electronic means and the taking of photographs. Now, there are caveats. You can't photograph the jury. You can't photograph some of the witnesses. I believe if the witnesses or somebody objects, then the judge can revoke it. If it's going to disrupt the court, the judge can revoke it. You can only have one camera. You can only have one still photographer, et cetera, et cetera. So there are some limitations on it. But you can, in Ohio, if you submit the written document for permission, you can record with some caveats. But he obviously didn't take the time to do that. Just like he obviously didn't take the time to read the criminal trespass statute. No person without privilege to do so shall do any of the following. 1. Knowingly enter or remain on the land or premises of another. He lacked privilege to do so, so as soon as they told him he had to GTFO, and he didn't, it became criminal trespass. Or number 2, knowingly enter or remain on the land or premises of another, the use of which is lawfully restricted to certain persons, purposes, like court business, modes, like not recording, or hours, when the offender knows the offender is in violation of any such restriction or is reckless in that regard. A reasonably prudent person would gather very quickly from the police officers that he's not allowed to film in there. And you might notice this little portion that I have highlighted. It is no defense to a charge under this section that the land or premises involved was owned, controlled, or in custody of a public agency. Womp womp. Suddenly, I'm finding Mr. Bush's legal analysis lacking or dubious. Frivolous, perhaps even, dare I say. What else did he mention? He mentioned obstruction of official business, no person without privilege to do so, and with purpose to prevent, obstruct, or delay the performance of or by a public official in any authorized act within the public official's capacity shall do so, or shall do any act that hampers or impedes a public official in the performance of the public official's lawful duties. It might have been that one. There's also a obstructing justice, but I don't think it's this one. I think this is what he was talking about, obstruction of official business. And then failure to disclose personal information. We've established that there is at least probable cause of criminal trespass. Whether or not he is found guilty remains to be seen. I don't think he has a very good case. And obstructing is attack on charge. It's contempt of cop. But failure to disclose personal information. No person who is in a public place shall refuse to disclose the person's name, address, or date of birth when requested by a law enforcement officer who reasonably suspects either of the following. 1, the person is committing, has committing, or is about to commit a criminal offense. Ta-da! Slam dunk lawsuit? No. Slam dunk prosecution? Yeah. Thanks for watching. Have a great day.